Washington Journal continues.
Welcome back. We're joined now by Jeffrey Rosen. He's the president and CEO of the National Constitution Center, author of the book called The Pursuit of Happiness. Jeff, welcome back to the program.
Wonderful to be back.
So let's start with your reaction to yesterday's Supreme Court ruling on immunity.
Couldn't be more important and historic. It's really important for C-SPAN viewers to read the majority opinion and the dissent. The majority says that it's crafting a rule of immunity for the ages that's necessary to protect future presidents against political prosecutions by their successors. And the dissent says that this is an invented rule without basis in constitutional text, history, or structure that will imperil democracy and, in Justice Jackson's words, is a five-alarm fire for the future of America. So it's really, of course, there are many important historic Supreme Court decisions, but it's striking that in this one, both the majority and the dissent really emphasize the historic stakes, and they have a completely antithetical view about what the Constitution requires.
Explain presumptive immunity. What does that mean?
It means that we presume that the president has immunity, but that can be overcome by showing that the act is not official. And the majority opinion establishes three categories of immunity. One, absolute immunity for activities at the core of the president's Article II function. Second, presumptive immunity for conduct that is at the periphery of those core activities. And third, unofficial acts for which there's no immunity. Now, the dissent says it's very unclear what the line between these categories is, and that inviting lower courts to make these fact-bound determinations, the majority is creating so much confusion that in practice, immunity will exist in all categories and the president will be above the law. But that's the nature of the dispute.
So what do you think the impact will be, especially based on what we know about what the founders intended, or what we think we know about what the founders intended for presidential power and checks and balances? This
is the most important question, and it's so important to discuss it as we approach July 4th, to think about what the founders would have intended. The majority and dissent disagree about this. Both cite Alexander Hamilton, and in particular, Federalist 77 is cited in both opinions, and Hamilton's insistence that there should be energy in the executive. And the majority cites that to support its conclusion that the president has to have broad immunity or else he'll be chilled or deterred from vigorously exerting presidential power. And the majority quotes Hamilton's Pacificus letters, where he talked about the importance that there be unity in the executive and the president be able to act with vigor and dispatch. The dissent says they're completely misreading Hamilton, and Justice Sotomayor goes on to quote Federalist 77 to say, of course, the president has to be vigorous, but he'll be amenable to prosecution. And Justice Sotomayor says this meant that Hamilton assumed that the major check on the president would be that, like any citizen, he would not be above the law and could, in fact, be prosecuted in criminal court. And Justice Sotomayor also quotes other framers of the Constitution, in particular James Wilson. He was the guy who came up with the idea that we, the people of the United States as a whole, are sovereign, and also James Iredell and Charles Pinckney, all of whom at various points in the convention and after said that they imagined the president would be liable to criminal prosecution. And Justice Sotomayor accuses the majority of being bad originalists. She says there's literally no basis in constitutional text, history, or structure for this principle. It's a made-up, invented principle designed to ensure that the president isn't chilled in the exercise of his duties. And she basically says history only matters to the majority when it cares about it, in the gun control case, but here it's ignoring text and history. That's another thing that makes the dispute between the majority and the dissent so important and vigorous.
So back now to the present day, the January 6th trial goes back to the lower courts. What does this mean for Judge Tanya Chutkan? What are her options?
Well, she has a lot of work to do under this opinion, because she has to go through the major categories of conversations or activities in the indictment and on a case-by-case basis decide whether or not the acts were official. The majority opinion says only one category of act is core executive functions, and that's the president's conversations with his acting attorney general, and that the majority says is immune from prosecution. But as to the other categories of discussions, in particular, the president's discussions with his vice president in his effort to get Mike Pence not to certify the election results, as well as the president's conversations with state election officials, as well as the president's tweets after January 6th, in all those cases, the judge has to decide whether or not they were core official acts or at the periphery of the president's core powers. The dissent says there's little guidance in making that determination and that the judge is kind of at sea in trying to decide whether or not it was official, but she has to go through all those activities. Then there's yet another important complication, and that's last Friday, the court in the Fisher case narrowed the scope of the Sarbanes-Oxley law that makes up 2 of the 4 charges against President Trump in the January 6th case. And the majority in a footnote says that the judge can decide, based on that Fisher opinion, whether or not those 2 charges can survive. So those are among the things that you will have to do on remand.
And if you've got a question for Jeffrey Rosen, he's the president and CEO of the National Constitution Center, you can give us a call. Our lines are bi-party, Democrats 202-748-8000, Republicans 202-748-8001, and Independents 202-748-8002. You can start calling in now. Regarding the other cases against former President Trump, including in Georgia and the Mar-a-Lago case in Florida, how does this affect those?
Well, in each of those cases, there will have to be a determination about whether or not the president is being charged on the basis of official acts or acts at the core of his power. And he'll move to have total immunity found and to have the charges dismissed accordingly. And the judges in those cases, too, will have to make a fact-based determination about whether or not the acts were official.
And as far as official, unofficial, is it always a court that decides that? Which court? How is that decided? And then does everything get appealed? Because doesn't it seem like to be maybe an opinion?
Absolutely. Another great question. And the dissent says this new test has one clear effect, and that's to empower courts to diminish the power of Congress to regulate the executive and to exalt the executive and the ability of courts to decide. And yes, indeed, in each of these cases, courts, trial courts will, as a preliminary matter, make the determination. Each of those determinations could be appealed. Each of them could ultimately be decided by the U.S. Supreme Court.
And there's reporting that Mr. Trump's lawyers have moved to overturn the Manhattan conviction based on this ruling. Is that possible?
My understanding of this is that to the degree that he was paying hush money to Stormy Daniels, none of those acts could plausibly be considered anywhere near the core of his executive functions. And therefore, my sense is that those charges will not succeed, but I suppose the judge will, in fact, have to rule on them.
All right, and we'll take some calls now. Christopher is up first, independent line, Navarre, Florida.
Yeah, I wanted to talk about how Barack Obama can benefit from this ruling from the Supreme Court. As we all know, there was a young gentleman, an American citizen named Anwar al-Awlaki, who was assassinated by Barack Obama without due process. He was an American citizen, and that is against the law, but he is the president, right? So, I mean, we need to start being real about what we're talking about instead of being hyperbolic. And we're ruining the country by not being honest with one another. I'm telling you right now, ignorance comes from the root word ignore. And we are ignoring all the stuff we should be paying attention to.
All right, Christopher, what do you think, Jeff?
Very good point that the biggest beneficiaries of this decision will be former presidents. And President Obama cannot be prosecuted for stuff he did in office. And of course, President Biden, if he ends up not being reelected, will not be able to be prosecuted by his successor. Now, the dissent notes the example that you gave of a drone strike. And even under existing law, there's no question that ordering drone strikes is the core of the president's Article 2 powers to execute the law. And therefore, he would not have been able to have been prosecuted on the basis of drone strikes even before this opinion. But no question at all that the whole thrust of the decision is that presidents shouldn't be deterred from vigorously exercising their Article II power, and therefore the biggest beneficiaries of this decision today will be former presidents of the United States.
You said even before this decision, former President Obama could not have been prosecuted for that drone strike.
That's correct. There's no existing criminal statute that would cover a president's exercise of his take care responsibility in the military, and that was a point that the dissent made. You didn't need immunity to immunize presidents from their wartime decisions.
All right, and Richard in Louisville, Kentucky, Republican.
Hello. Can you hear me?
Yes, we can.
You know, I'm not a constitutional lawyer by any means, but in listening to everything that's happened, I listened to John Roberts when he spoke of this ruling is for the ages. And everyone keeps saying it's about Donald Trump. Donald Trump just so happens to be in the position that he was president of the United States. And he's the one that asked the Supreme Court to rule on some of the things that he did as president of the United States. And they come back and they said, well, this is for all presidents, past and future. So I'm a young woman. I'm brilliant. I'm through college. I proceed with my life. I run for office. I'm a congresswoman. I become governor, and then I decide to run for president of the United States. And if I didn't have immunity to protect my backside that says you run the strongest country in the world, and sometimes you have to do things that people are not going to like. Am I protected? John Roberts and the Supreme Court of the United States said, yes, you are. And that's all I wanted to hear. And I'm just a dumb old plumber. Thank you.
Don't say that, Richard. Can you explain, Jeff, Amy Coney Barrett's concurrence, and what were the lines that she was drawing?
It's hugely important. And in all of these cases, I really want C-SPAN viewers to read the majority opinion, read the concurrence, and read the dissent. They're written for American citizens, and you can read them and make up your own minds. Justice Barrett said the following. She doesn't agree with creating a broad new presumption of immunity for the president. She would have taken a different approach and asked two questions. First, does the criminal statute at issue apply to the president's actions? And second, if it does apply, would applying it to the president unduly intrude on executive functions? And therefore, in the case we've been discussing of an ordering a drone strike, she would have concluded that the murder statutes don't apply and wouldn't have had to proceed it to the next question about whether or not there's an undue intrusion on executive functions. For all those reasons, she disagreed with the idea that conversations with executive officials could not be introduced to prove criminal offenses. And she gave the example of bribery. She said if the president corruptly took money in exchange for a bribe, it would certainly be appropriate to introduce evidence of his conversations with the vice president or other executive officials to prove his motives. She saw no reason to exclude that evidence, as the majority would have done. And more broadly, she just challenged the whole idea of thinking of this as a form of immunity rather than a fact that the substantive criminal laws can't be applied in ways that unduly intrude on the president's function. And she said that in that sense, she broadly agreed with the Biden administration's position. It's striking that the majority of the court rejected her approach. It's conceivable that there might have been a moderate consensus around an approach like the one she suggested, but her conservative colleagues wanted to take a broader approach, and that was the nature of the disagreement.
Next call is Olu in Gwynn Oak, Maryland, Democrat.
Yeah, good morning. Thanks for picking my call. Yesterday was just a dark moment for the United States, and it's so unfortunate that we found ourselves here. Given Donald Trump or the Supreme Court decision about president should have some type of immunity, it's just giving them access to do what they want to do. First of all, I don't think there's any reason for any president to be thinking about how they're going to do their job, other than to just do what their advisors, the Attorney General, advise them to do. But in this case, I think it's now time we need to disband to the Supreme Court because it's just so bipartisan. So it's really a sad time around here. But again, giving immunity, we shouldn't even be talking about it. So it's just a leverage for them to do what they want to do. Get in the office and do the right thing. That's all. Thank you.
All right. And, you know, there have been callers that have made the point of, okay, well, this means that President Biden can just arrest former President Trump, his whole family, say he's a threat to democracy, put him in prison, do whatever he wants. I mean, is that true?
So what the caller's point is one that Justice Sotomayor made as well. She said that to the degree that the president is deterred from acting in ways that violate the criminal laws, that's a good thing. That's what criminal laws are for, and you don't want to give the president an incentive to ignore them. The majority takes a different view and is very concerned with the idea of a President Biden trying to prosecute a President Trump or future President Trump in a second term prosecuting a President Biden. And that's the main reason that they've created or recognized a new form of immunity for former presidents. Because remember, that's what's novel about this decision. It's not a question of immunity from prosecution for sitting presidents in office. That was something that no one ever challenged. This is the first time in history that it's immunity for former presidents that have been created. And it's created precisely for this reason, so that while presidents are in office, they won't be afraid of future prosecutions once they're out of office. And that's the nature of the discussion between the majority and the dissent.
Karam in Beltsville, Maryland, independent.
Good morning.
Morning.
My question is it's a two-part question. Number one, I mean, to your previous point, you were just saying this applies to even presidents who are out of the office. Does it imply for actions that were out of the office, like having things in your garage or things in your estate, like that you're not supposed to have classified documents? And before, like you became into presidency while you were running, in cases like the Stormy Daniels case, like does it apply before and after, or for actions only during your presidency? Number two is, how does this positively or negatively affect all of the other cases that Donald Trump had? Thank you for taking my call.
Two great questions. It does apply to proving alleged criminal activity that took place before you came to office or after you came to office. In other words, you're not immunized for stuff you did before or after, but you won't be able to introduce conversations that you had while you were in office in order to prove the subsequent actions. That's the nature of the dispute in the January 6 cases. Can his conversations with his attorney general or vice president be introduced to show stuff that he did related to the election that took place after the election? So that's the nature of the dispute, and the dissent just says it makes it much harder to prove those previous or subsequent actions if you can't note anything that he did in office to prove a motive. And then how does it apply to the other cases? My sense is that in each of them, President Trump will move to dismiss the cases, claiming that they're based on immunized conduct, and the judges in all those cases will have to decide whether or not the conduct was immunized or not.
There's another key decision. This one came last week, overturning the Chevron doctrine. Can you explain what that is, and what does it mean that it's overturned now?
Absolutely. Another hugely important decision, also written by Chief Justice John Roberts, as was the gun control case. The major decisions of this term, all written by Chief Justice Roberts. And Chevron was a decision that was in place for almost 40 years, and it held that when reviewing courts are looking at regulations that administrative agencies pass, like environmental regulations or securities regulations, they have to ask two questions. First, did Congress speak clearly on the issue in question? If it did speak clearly, then the matter for courts is at an end. They've got to enforce what Congress wanted. But if Congress's intent is ambiguous, according to Chevron, courts should defer to the administrative agency. So, for example, if there's an environmental regulation and it's ambiguous whether or not the statute authorizes it, the court should defer as long as the regulation was reasonable. This decision last week, called the Loper-Bright decision, overturned Chevron and says that there should not be a presumption of deference in the face of ambiguous statutory language, but instead courts should decide for themselves whether or not the regulation is consistent with the statutory text. They can take the administrator's views into account, but they've got to exercise their own independent judgment. And the majority said that this was consistent both with principles of separation of powers, which shouldn't unduly exalt executive deference, and also with the text of the Administrative Procedure Act, which was passed after the New Deal, to tell courts what to do when they were looking at regulations. The dissent, and again, there's a vigorous dissent, and viewers have to read those decisions. You can find them easily online and read the majority opinion and the dissent. The dissent by Justice Kagan said that this would fundamentally transform the administrative state and exalt judges at the expense of the executive. And Justice Kagan said judges are not experts in questions like environmental policy or security regulation, and it's a failure of humility to exercise their own independent judgment. In a related case a year or so ago, Justice Kagan said, now this court is in charge of all environmental policy and climate change. That's scary, were the words that she used, because she suggested judges aren't experts, and that was the whole reason for Chevron deference.
She said this court is making itself into the country's administrative czar.
Strong language and vividly chosen, and she is concerned that the court is abrogating decisions that are best left to politically accountable officials. She actually wrote a really important law review article when she was a professor, endorsing the idea of a vigorous executive, a unitary executive in the spirit of Hamilton, but saying that that means that every time a president wins an election, he or she should be able to appoint agency administrators who reflect the policy views that he was elected to put into place, and that it's a failure of democracy for judges to substitute their own understanding of complicated regulatory policies for those of politically accountable officials. Another hugely important separation of powers opinion, and in both cases, isn't it interesting, both the immunity decision and the administrative decision, the dissenters are accusing the majority of exalting judges, of being judicial supremacists, of increasing judicial power at the expense of the president in the case of Chevron and Congress and the president in the case of the immunity.
And do you think that what do you think the long-term impact will be practically for the American public of the Chevron decision?
Well, the majority and dissent disagree about this. The majority says this isn't going to be a big change, that in practice Chevron already hadn't been cited by the Supreme Court or by lower courts for the past decade or so. Judges had been increasingly exercising independent review, and they'll just keep doing that. The dissent said this is a fundamental challenge to the essence of the administrative state, of the regulatory state, and that ever since the New Deal era in the 1930s, the regulatory state had gotten lots of deference from the courts. Ever since after the Supreme Court in 1937 got out of the business of striking down administrative decisions by applying skeptical scrutiny. And the court said that this would both turn judges into administrative czars and also basically drive a stake through the heart of the administrative state.
Let's talk to Cheryl in Holly Hill, Florida, Republican.
Hi, thanks for having me on. First of all, the ruling was absolutely probably the best that could have come out of this, and it protects all presidents, not just Trump. And this attack on the Supreme Court for their ruling by the left is ignorant and very, very dangerous. And to hear that from Biden himself on the world stage is unbelievable for a man who has done nothing but break the rules. And he spit in their face directly and bragged about it. It regards the student loan debt that he transferred onto the backs of hardworking Americans and opening that border and putting our national security directly at risk. Directly. He violated his oath of office. How many times? I can't even count. But it's dangerous to be saying that all of a sudden a president can get a SEAL team to shoot somebody. That's common sense thrown right out the window, and it's ignorant for people to say that kind of stuff. We know that doesn't apply there. There's no common sense in this country whatsoever anymore. And you even said it. Your guest even said it. The immunity ruling was meant to protect, historically, to protect sitting presidents from prosecution even after they left office, which is post-office, which is previous presidents. And yes, they should be protected from immunity because a whole lot of people could be prosecuted for things they did while in office. So Biden is a very, 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 very dangerous man to say the things he's saying to the world.
All right, Cheryl. And comment, Jeff?
Well, it's very important comment that the nonpartisan legitimacy of the rule of law is what holds us together nowadays. And we are indeed seeing attacks on that nonpartisan legitimacy by both sides, both by President Trump after his criminal conviction when he attacked the jury and the prosecution, and by President Biden when he criticized this decision, although he did not criticize the legitimacy of the courts. He accepted the ruling but said that he strongly disagreed with it. So I think it's a good point that all elected officials need to be mindful when they talk about judicial decisions. Absolutely fine vigorously for a president to say he disagrees with a decision. That's what President Lincoln did. And indeed, the Supreme Court last week cited Lincoln's refusal to accept the finality of the Dred Scott decision as a justification for overturning precedent. Justice Gorsuch, in his concurring opinion in the Loper-Bright decision, said precedents are not sacrosanct, and it's fine for presidents to criticize them and, in fact, to try to argue for them to be overturned. So criticism is fine, but attacking the legitimacy of the rule of law itself is more troubling.
Warren is a Democrat in Arkansas. Hi, Warren.
Good morning. How are y'all doing today?
Good.
I want to make a statement. The conservatives, every bill that I can remember, and I'm almost 90, I'm 8 or 9, the conservatives screws it up. They screwed up the slave bill. They screwed up the civil rights bill. They screwed up the voting rights bill. Now they screwed up the Supreme Court. They done screwed up the presidential. Well, can't President Biden have Trump put out before he be elected if he want to, if this law going to be law? And Vice President is in place in case something happened to President Biden. She is qualified. She is able to take over and run this country. Trump is not have the ability to run government. Trump is not a businessman. Trump is a man in business. Buy business and run them in the ground and take the money and run. Trump is not a businessman. Trump can't be president.
All right, Warren. Any comment on the ballot cases? There was, there was the case that was decided a while ago about Trump being on the ballot because of the 14th Amendment.
Of course, another hugely important case of first impression in the sense that the court had never ruled on the scope of Section 3 before. And that's another case where the majority and dissent are strongly disagreeing about original understanding. The majority, self-described originalists in many cases, held that the 14th Amendment Section 3 is not self-executing and that Congress has to act before a candidate can be disqualified, and cited as a precedent Chief Justice Chase's holdings during the Civil War that held that Congress has to act before former insurrectionists can be disqualified. And the dissent once again said, you're making this history up, that there's nothing in the text or history of Section 3 which suggests that Congress has to act first. And in fact, in a related case during the Civil War, the Chief Justice had seemed to suggest that the Section 3 was self-executing and no congressional action was necessary. and therefore, said the majority, once again, you're expanding judicial power at the expense of the clear text and history of the amendment.
Gilbert in Toledo, Ohio, independent. Good morning.
Good morning. How are you doing?
Good.
Okay, I stayed up late last night listening to Lawrence Tribe, a constitutional lawyer and teacher, and he's basically saying the same thing that your guest is saying. Very nice guest. Anyhow, I'm left with one question: who gets to decide on all this? Is it the Supreme Court? A person who people did not elect? Is that the people who are going to decide? And I look at these people who've been taking bribes and money, millions of dollars, and they got to rule on this. I just can't understand why they got to rule on this when they're clearly trying to, I would say, overthrow the government. That's what I'm looking at. I don't know how you're seeing it, but I think Lawrence Tribe said it, and this gentleman said it. It's very dangerous what they're doing. And the women on the Supreme Court, who are much smarter than the men, women are just voicing this and echoing this. I would just like to know this, what this man thinks.
This question you identify, who decides? That's one of the central questions in all of these Supreme Court decisions. Who decides? Should it be the people of the United States through their elected representatives? Should it be the president as representative of the people, or Congress? Or should it be judges? And in all of these cases, the liberal dissenters are claiming that the court is wrongly abrogating power for itself and making federal judges in particular the last word in deciding, and in that sense subverting or second-guessing the democratic process. Interestingly, that was exactly the charge that conservatives made during the Warren era and the Berger era, that liberal judges were subverting the decisions of elected representatives and exalting their own power, and now the tables are turned. I appreciate your nice words. I'm trying to just describe the arguments on both sides, because that's my job at the National Constitution Center, and I do at this point want to make a plug to C-SPAN viewers for the amazing interactive constitution that the National Constitution Center has. At constitutioncenter.org, we've assembled the greatest conservative and liberal scholars in America to write about every clause of the Constitution, describing what they agree about and what they disagree about, so that you, C-SPAN viewers, you the people, can decide. And for example, if you click on the habeas corpus clause, you'll see Justice Amy Coney Barrett, when she was a law professor, and Neil Katyal with 1,000 words about what they agree the clause means, and then separate statements what they disagree about. It is marvelous. It is this extraordinarily rich and important civic resource. You can go to any of the clauses we've been talking about, Article 1, Article 2, the Second Amendment, read the essays on all sides, read the primary text associated with them, watch the videos, listen to the podcast I do every week, We the People, that brings together liberals and conservatives, so that you can make up your own mind, because in the end, in America, we the people have to decide.
And Independence Day is day after tomorrow. I just wanted to touch on your most recent book, which is called The Pursuit of Happiness: How Classical Writers on Virtue Inspired the Lives of the Founders and Defined America. What did the founders mean by the pursuit of happiness, and why do you think they put that in?
This was the most meaningful COVID-era reading project I've ever engaged in. I set out to figure out what Thomas Jefferson and the other founders had in mind when they used that famous phrase. And I read the books on a reading list that Jefferson would send to anyone who asked him the meaning of happiness when he was old. And in the section on ethics, there are Stoic philosophers like Marcus Aurelius, Cicero, and Seneca, and then Enlightenment philosophers like John Locke and Francis Hutcheson and David Hume. And when I read those books, I was struck first that all of them contain the phrase the pursuit of happiness, and they define happiness not as feeling good, but as being good, not the pursuit of immediate pleasure, but the pursuit of long-term virtue. And by virtue, they meant self-improvement, character improvement, self-mastery, being your best self, overcoming your unreasonable passions and emotions, like anger, jealousy, and fear, so you can achieve the calm, tranquility that allows each of us to be our best self and serve others. It was a transformative experience for me to recognize the close connection the founders see between personal self-government and political self-government. Unless citizens engage in this daily self-mastery through self-improvement, they think the republic will fall. And the book sets out to profile all of the founders, Franklin and Adams and Abigail Adams, and lesser-known great founders like Phyllis Wheatley, the first black poet, and Mercy Otis Warren and James Wilson, and ask how do they apply these lessons in their lives. It turns out they struggled constantly with anxiety, with self-doubt, wondering whether they were using their industry enough. But what's so inspiring about all of them is what deep readers they were. And if there's a single takeaway from the project for me, I had fallen out of the habit of doing daily reading, and kind of inspired by Jefferson's schedule, I got up every morning, read for 2 hours, watched the sunrise, wrote these crazy sonnets sort of summing up what I'd learned, and I've tried to keep that habit of deep reading ever since. So now when I wake up, I have this rule. I'm not allowed to browse or surf until I've done my reading, and it's amazing how much reading you can do when you do it every morning, and I'm so grateful to the founders for having inspired this practice of deep reading.
And Max is in Maryland, Republican. Good morning, Max.
Hey, thank you for taking my call. So this was an interesting discussion, and it was breezed over quite quickly, 2 points that were at the crux of this decision made by the Supreme Court. What was asked was, could the current president detain the former and current political rival of the current president and be immune for such things after he's out of office, regardless of how it all unfolds? I mean, he could, under the auspice of, I'm protecting democracy and, we're going to preserve democracy, we're going to lock up our political enemy. I mean, you could, in this instance, do that. And then on top of that, you just glossed over the fact that if you don't agree with somebody and you believe that they're also a danger to democracy, that you can drone attack them as long as they're offshore, not on the soil of the United States.
You're so right that the whole focus of the majority opinion is the danger that a former president might be prosecuted by a vindictive sitting president. That's what the whole immunity is designed to prevent, because after all, it's the sitting president who controls criminal prosecutions, and the fear that those vengeful prosecutions might deter the now former president while he's in office is the focus of the majority's concern. And your drone strike example is also one that the dissents use. Justice Sotomayor says a former president, uses drones or uses his authority to assassinate a rival. Immune, she uses very vivid language. So that's the nature of the dispute, and you've put your finger on it.
All right. Well, Jeffrey Rosen, National Constitution Center President and CEO, author of the book, The Pursuit of Happiness. Thanks so much for coming in, and happy 4th of July later this week.
Happy 4th of July. Remember, the 2nd is the date that the Declaration of Independence was actually voted. So John Adams thought today was the day that should be celebrated with parades, and let's celebrate today, tomorrow, and on July 4th.
I'm all for that. Thank you so much.
Thank you.